Although the parties may have addressed this court on the applicability of Nabam Rebia, the order dated 27 June 2022 did not rely on Nabam Rebia to injunct the Deputy Speaker from adjudicating the disqualification petitions on the ground that a notice of intention to move a resolution for his removal had been issued. This court instead granted an extension of time to the persons against whom disqualification petitions were filed to file their written submissions in view of the principles of natural justice. Based on the submissions which have been canvassed before us, we are of the view that the decision in Nabam Rebia merits reference to a larger bench because a substantial question of law remains to be settled. The following are our prima facie reasons for reaching this conclusion. I'll not read out all the reasons for the reference to a larger bench of Nabam Rebia, save and except to note one thing. It appears that the following aspects were not considered in Nabam Rebia. 1. Whether the temporary disablement of the functions of the Speaker under the 10th schedule is prone to misuse by MLAs who anticipate that disqualification petitions will be instituted against them or by MLAs against whom disqualification petitions have already been instituted. And 2. Whether a constitutional hiatus in the operation of the 10th schedule ensues because of the temporary disablement of the Speaker. To give quietus to the issue, we refer the following question and any allied issues which may arise to a larger bench: whether the issuance of a notice of intention to move a resolution for the removal of the Speaker restrains them from adjudicating disqualification petitions under the 10th schedule of the Constitution. Then we have said that pending the decision of the larger bench, as an interim measure, adoption of the following procedure may subserve the objective of the 10th schedule, the symbols order, as well as Article 179C. It may also provide some amount of clarity and certainty. And the points which we have then made for the interim is that the investing of exclusive adjudicatory jurisdiction upon the Speaker to determine the complaints under the 10th schedule will entitle the Speaker to rule upon and decide applications questioning their jurisdiction. B. 1. The Speaker is entitled to rule on applications that require them to refrain from adjudicating proceedings under the 10th schedule on the ground of initiation of a motion for the removal under Article 179C. A Speaker can examine if the application is bona fide or intended only to evade adjudication. 2. If the Speaker believes that the motion is well-founded, they may adjourn the proceedings under the 10th schedule till their decision of their removal is concluded. On the other hand, if they believe, page 61 ko correction hai, if they believe that the motion is not as per the procedure contemplated under the Constitution, read with the relevant rules, they are entitled to reject the plea and proceed with the hearing. And 3. The decision of the Speaker either to adjourn the proceedings under the 10th schedule in view of the pending proceedings under Article 179C or to proceed with the hearing will be subject to judicial review. As the decision of the Speaker relates to their jurisdiction, the bar of a quae time action as contemplated in Quixote Holohan will not apply. Now, having referred the matter to a larger bench, we have given our reasons for coming to the conclusion that we are still dealing with the matter on merits because Nabam Rebia, strictly speaking, did not arise in the matter before us, but we thought Nabam, the controversy, should be settled by a reference to 7 judges. So I'll now go to the what we have said on the merits of this particular case.
इस वक्त की बड़ी खबर, महाराष्ट्र का मामला बड़ी बेंच को सौंप दिया गया है। 5 से ज्यादा जजेस की संविधान पीठ अब इस पर फैसला लेगी। स्पीकर की शक्तियों पर फैसला बड़ी बेंच करेगी।
इंडिया टीवी हर वक्त हर जगह डाउनलोड करने के लिए सर्च करें इंडिया टीवी न्यूज़ गूगल प्ले स्टोर या ऐप स्टोर पर।